Hi, happy Easter, everyone. Let's be motivated once again by those more than 8,000 bar passers this year. I will be reading the questions and answers for Remedial Law Review 1, 2020 and 2021 edition from sources online. I will be mentioning in the caption the authors. No infringement is ever intended. Per your suggestions, let us read it per rule and let's see if this is more effective. Now, this is the introduction part. Remedial law is that branch of law which provides for the jurisdiction of courts and the rules concerning pleading, practice, and procedure before the courts. The primary sources of remedial law are the following: BP 129 or Judiciary Reorganization Act of 1981 and other special laws which provide for the jurisdiction of the court. Number 2, the rules of court. Number 3, decisions of the Supreme Court. Number 4, circulars, resolutions, and other administrative issuances of the Supreme Court. And finally, the Constitution, particularly Article 8 of the Constitution on the judiciary. May Congress repeal, alter, or supplement rules concerning pleading, practice, and procedure? No. The power of Congress under the 1933 and the 1973 constitutions to repeal, alter, or supplement rules concerning pleading, practice, and procedure was taken away in the 1987 Constitution. This is in the case of Echegaray versus Secretary of Justice, GR 132601, January 19, 1999. This is also found in Isagani Cruz Political Law Review or book, page 246. The GSIS argued that it is exempt from the payment of docket and legal fees by virtue of RA 8291, which exempts it from all taxes, assessment, fees, charges, or duties of all kinds. Is the GSIS correct? No. In the petition for recognition of the exemption of the government service insurance system from payment of legal fees, AM number 082-0101, February 11, 2010, AM number 08-2010, February 11, 2010, the court ruled that the provision in the charter of the GSIS, that is Section 39 of Republic Act number 8291, which exempts it from all taxes, assessments, fees, charges, or duties of all kinds, cannot operate to exempt it from the payment of legal fees. This was because, unlike the 1935 and 1973 constitutions, which empowered Congress to repeal, alter, or supplement the rules of the Supreme Court concerning pleading, practice, and procedure, the 1987 Constitution removed this power from Congress. Hence, the Supreme Court now has the sole authority to promulgate rules concerning pleading, practice, and procedure in all courts. GSIS versus Caballero, GR 158090, October 4, 2010. Under S22 R 141, while the Republic of the Philippines and its agencies and instrumentalities are exempt from paying legal fees, local governments and GOCCs, with or without independent charters, are not so exempt. How are actions or proceedings classified? According to subject matter: number 1, real action; number 2, personal action. According to binding effect: number 1, action or proceeding in rem; number 2, action in personam; number 3, action quasi in rem. Define a real action and personal action. A real action is one which affects title to or possession of real property or interest therein. A personal action is one which does not affect title to or possession of real property or interest therein. Examples of real actions: action to recover ownership or possession of land, foreclosure of real estate mortgage, partition, and ejectment. Examples of personal actions are action to recover ownership or possession of personal property, action for specific performance, and action for collection of sum of money. The importance or practical significance of distinguishing between a real action and a personal action. The distinction is important for purposes of determining the venue of the action and the court having subject matter jurisdiction thereof. The venue of real actions is the proper court which has jurisdiction over the area wherein the real property involved, or a portion thereof, is situated. On the other hand, venue of personal actions lie in the place where the plaintiff or any of the principal plaintiffs resides, or where the defendant or any of the principal defendant resides at the election of the plaintiff. Jurisdiction over real actions depends upon the assessed value of the real property involved. Jurisdiction over personal actions depends upon the amount of the claim or demand. BP 129, provided that if the subject of the litigation is incapable of pecuniary estimation, of course, jurisdiction is vested in the RTC. What is action in rem? An action or proceeding in rem is one which is not directed against a particular person, but on the thing or res itself, and which asks the court to make a declaration of or to dispose of or deal with the res. The thing or res may be personal or real property, or it may be a status, right, or particular fact. Examples of action or proceedings in rem are: 1. Application for original registration of a parcel of land. Special proceedings, the object of which is to establish the res, that is, status, right, or particular fact. Number 3. Petition for declaration of insolvency. Number 4. escheat proceedings. Number 5. Petition for change of name under R103. An action in personam is one which is directed against particular persons and seeks a relief which would be binding only upon such particular persons. Examples are action for a sum of money or for specific performance. What is an action in rem or an action quasi in rem? An action quasi in rem is one which is directed against particular persons but seeks to reach and dispose of or deal with their property located in the Philippines. The case would be Midgley versus Honorable Fernando, May 13, 1975. It is similar to an action in rem in that the purpose is to dispose of or deal with property rests in the Philippines. However, like an action in personam, it is brought against particular persons, and the judgment therein is binding only upon the parties thereto. San Fernando versus Ong, GR 177598. Examples of action quasi in rem: judicial foreclosure of mortgage. Number 2, action in personam in which property of the defendant has been attached. The attachment converts the action to one quasi in rem. 2, citizens surety or an insurance company versus Melencio Herrera. Action for partition and accounting, Valmonte versus CA 252 SCRA 93. And number 4, action to quiet title and to remove cloud, San Fernando versus Ong. Finally, action for partition. Is an action for ejectment an action quasi in rem or in personam? It is an action in personam since the action is binding only between the parties. Domagas versus Jensen, GR 158407. January 17, 2005. It is submitted that the action is one quasi in rem since the real object is to exclude the defendant from possessory interest over the property, and hence extraterritorial service may be availed of, whether characterized as in personam or quasi in rem. The judgment in an ejectment suit is binding only between the parties. How about an action to recover title to or possession of real property? Is it personam or quasi in rem? It is a real action, but an action in personam. Republic versus Court of Appeals. For the same reason as stated in the preceding answer, it is submitted that the action is one quasi in rem. And why is it important to distinguish an action in personam from an action in rem or quasi in rem? Extraterritorial service under Section 17, Rule 14 may be affected in actions in rem or quasi in rem, but not in an action in personam. Valmonte versus CA. On the other hand, Section 16 and Section 18 of Rule 14 apply to any action, including actions in personam. In preliminary attachment, the requirement of prior or contemporaneous service of summons shall not apply where the action is in rem or quasi in rem.